Can a landlord charge an existing tenant utilities in their rental agreement? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, I got a question emailed to me about the situation was this. They have an existing tenancy right now, and they wanted to charge the tenant-specific utilities. Okay, that's all I remember about the question. And the answer to that question is it really depends. It really depends on a couple different factors, actually. So number one is, do you actually have a written rental agreement? Because one of the things that you're going to need to actually enforce this type of lease provision is to have some type of written agreement about, okay, the tenant is going to pay XYZ utilities. Okay, well, it's best to have a written agreement. Okay, it's possible you can have it on an oral agreement, but it's super hard. Oral agreements are kind of hard to enforce. So that's a story for a different day here. The second thing is the landlord in a existing lease term, or is it a month-to-month agreement? Okay, because here's the deal. If you have an existing lease that hasn't expired yet, the landlord and tenant are bound by those terms of the agreement unless they come to a mutual agreement otherwise modifying that lease. So if the lease doesn't say that the tenants have to pay for utilities, then you're going to be out of luck, basically, until the next, when the lease expires. Maybe that can be negotiated, or if the agreement goes month to month, possibly using a change in terms of tenancy to to address those issues, which goes to my next point of, if it's a month-to-month agreement, it is possible for a landlord to give a notice of change in terms of tenancy to change how the tenant relationship is going to go, and state, hey, 30 days from now plus, you're going tenant's going to be responsible for certain utilities. Here's the catch, though, guys. These issues are very factually specific. You might have state and local rules that you have to abide by, particularly for landlords subject to the Tenants Protection Act of 2019, or a local eviction ordinance or rent control ordinance if you're subject to localized rent control. Changing the terms of utilities could be construed as increasing rent. There's a whole matrix of issues behind that. So I would probably exercise caution. This isn't legal advice, but I'd probably sit down with landlord's counsel or a lawyer of your choice to kind of go over the lease, look at your local rules and regulations, make sure you're not, if you try to change the terms of the deal here, you're not going to run into hot water. Okay. So those are kind of my thoughts on that, but it is possible to change that relationship, that arrangement about the utilities. So if you have a situation like this, feel free to reach out. If you're in the Northern California area, we might be able to help out. If you got questions, comments, put them down below. Until next time, folks, I'll talk to you then. Okay, see ya.